In Vikas Chaudhary versus State of Delhi, the appellants were imposed with imprisonment for 30 years without remission by the trial court, which was affirmed by the Delhi High Court. This judgment was challenged by the appellants, and the Supreme Court issued notice to consider the correctness of the sentence imposed on the accused or the appellants. The facts of the case are that the deceased, aged 18 to 20 years, was kidnapped by the appellants for ransom, and on the same day, he was killed by strangulation and the body was burned to eliminate evidence. The deceased father filed a missing person report with the police on that day itself, after which he received six ransom calls from January 2003 to March 2003 from different people seeking money in exchange for information about his son's whereabouts. On May 2003, the three accused persons disclosed where the dead body had been dumped, but it could not be recovered. Upon investigation, it was found that another police station in which jurisdiction the Nala fell had recovered a half-burned dead body one day after the abduction took place. This was identified by the father to be that of the deceased. Ms. Meenakshi Arora, the Law Senior Counsel appearing for the appellants, placed strong emphasis in the case of Union of India versus Sriharan Murugan, in which it was held that it was outside the jurisdiction of the trial court to provide a specific term punishment or till the end of ordinary life as an alternative to death penalty. She placed reliance on Section 386B, Clauses 2 and 3 of CRPC, which deals with the powers of the appellate court to argue that adjudication and examination of the order on sentence is necessary even when order of conviction has been upheld or modified under Section 386B, Clause 1. Also, the appellate court had to specifically hear the accused on the quantum and nature of sentence imposed upon him and call for the report of the officer under the Probation of Offenders Act and a psychological assessment report. She also relied on the case of Amit versus State of Maharashtra and Laxman Naskar versus State of West Bengal and argued that importance had to be given to the mitigating factors like the age at which the offense was committed. She also referred to the case of Rajendra Pralad Rao Vasnik versus State of Maharashtra and determined whether the accused, notwithstanding the crime, can be reformed, rehabilitated, or reintegrated. She stressed on the importance of theory of reformation through punishment. The counsel for the state, however, contended that this is a case of cold-blooded murder, as the act of abduction was committed in a clandestine manner and it was pre-planned and premeditated, which is very clear from the fact that the deceased was murdered the very next day after the abduction took place, and the family was made to believe that their son was alive and regularly demanded ransom from them. He placed his reliance on the case of Arvind Singh versus State of Maharashtra. He also argued that this case belongs to the category of the rarest of the rare cases, and the appellants were aware and had full knowledge of the actions as they were educated and from well to do families. Moving on to the analysis and reasoning by the Supreme Court, the court referred to the case of Bachchan Singh versus Union of India, which upheld that the imposition of capital sentence should be invoked in the rarest of the rare cases. In Machi Singh versus State of Punjab, it was held that there needs to be a just balance between the aggravating and the mitigating circumstances before the option of sentence is exercised. In Santosh Kumar Sadish Bhushan Barrier, a two-step process was pronounced to decide whether a convict deserved the death sentence. The first one is whether the case belonged to the rarest of the rare category. The second one is whether the option of life imprisonment is enough or not. The appropriateness of imposing a punishment termed as special or fixed term sentences in serious crimes was considered in the case of Union of India versus Sriharan Murugan, where it was held that while imposing life imprisonment for an offense for a specified period, it would be proportionate to the crime as well as the interest of the victim. And also the power to impose a modified punishment, providing for any specific term or till the end of convict's life as an alternate to death penalty can be exercised only by the High Court and the Supreme Court and not by any other inferior court. The court overruled its decision in Sankil versus State of Haryana by stating that awarding sentence of 20 or 25 years without any remission is not in consonance with the law. Thus, Sriharan approved an alternative third sentencing option in cases where the accused are convicted of serious crimes which carried with it the option of capital sentence. Therefore, only the Supreme Court and the High Courts had the option of imposing special or fixed term sentences. In Manoj versus State of Madhya Pradesh, considering several judgments and law commission reports, it was held that the society must strive towards a goal of reformation. The court deems it necessary to frame practical guidelines to systematically collect and evaluate information on mitigating circumstances. The practical guidelines are first one, to ensure that the mitigating circumstances are considered at the trial stage to avoid slipping into a retributive response to the brutality of the crime. The second one is the state must, in a time bound manner, collect additional information pertaining to the accused, like the age, early and present family background, type and level of education, etc. Third one is information regarding the accused jail conduct and behavior, work done if any, activities the accused is involved in, and other related details should be called for in the form of a report for the relevant jail authorities. In Anil versus State of Maharashtra, the Supreme Court directed criminal courts to call for the additional material while dealing with the offences like Section 302 IPC to determine whether the accused could be reformed or rehabilitated, which depends upon the facts and circumstances of the case. Now, in the present case, there was limited material regarding the mitigating circumstances of the appellants. So the court directed the preparation and submission of three reports, namely the report of the probation officer, report on nature of work done while in jail, and also the psychological and psychiatric evaluation report. On referring to these reports, the court came to the conclusion that both the appellants shared some commonalities as they were of young age at the time of offense, hailed from educated backgrounds, and they continued to enjoy the love and affection of their families. And the sole motive for this crime seems to be that of greed. Therefore, the court found it appropriate to modify the sentence awarded to both the appellants to a minimum term of 20 years of actual imprisonment. Thank you.
So, I would like to delve into the concept of continuing offense through a detailed analysis. So, Section 472 of the CRPC 1973 says that in case of a continuing offense, a fresh period of limitation begins to run at every moment of time during which the offense continues. Sometimes there comes a situation where an offense continues to occur over a prolonged period of time. So then, in such circumstances, it seems difficult to determine the period of limitation. The paramount object of inserting this provision is to safeguard the interest of the aggrieved person or a litigant in case an offense alleged is a continued one and enable courts in meeting the ends of justice as it should. And now, moving on to our case, which is Vikas Chaudhary versus State of Delhi, it specifically falls under the niche of abduction. And abduction is defined under Section 362 of the IPC. Uh, and it says that any person who by force compels or by any deceitful means induces any person to leave a place is said to commit an offense of abduction. Abduction is a continuing offense and continues so long as the movement of the abducted person continues from one place to another due to forceful compulsion and deceitful means. In our case, titled Vikas Chaudhary versus State of Delhi, the Supreme Court has observed that offensive murder coupled with abduction would be considered as a continuing offense and held that even after the death of the victim, every time a ransom call was made, a fresh period of limitation commenced. Accordingly, it would be the date on which the last ransom call was made, which was 11th March 2003, which has to be taken to be the date of commission of the offense, and accordingly, the Juvenile Justice Act was no longer applicable to the petitioner, who had attained the age of 18 years by then. And our case, in the present instance, the petitioner was a director in a uh, company known as Metal Crafts PVT Limited and Asta Apparel PVT Limited. And the economic interest of India was also included in Article 21 as per the dictum of Maneka Gandhi versus Union of India. And the behavior of that encompasses this particular case. These particular facts are also important because the deceased, who was between the ages of 18 and 20, was abducted on January 18, 2003, and held captive for ransom. He was strangled on the spot, and the body was burned to destroy any traces of his death. After filing a missing person report with the police on January 18, 2003, the deceased father, or the complainant in this case, got 6 calls from unknown callers requesting ransom in exchange for information regarding his son's whereabouts and safety. The 3 defendants were found guilty by the trial court of violating sections 302, 364A, 201 of the and 201 of the IPC. And when read in congruency with section 120B, A1 and A2, the current appellants were also found guilty under section 411 and were also found guilty of the offenses covered by section 420, 468, and 471. They were given a life sentence that would last the rest of their natural lives, with the additional requirement that A1 and A2 would be eligible for any parole, remission, or furlough before serving a total of 30 years in jail. Additionally, they were ordered to pay a fine of 2 lakhs and 10,000 rupees and 4 lakhs in restitution to the victim's family. And the appellants were cleared of all the charges by the High Court, and through the Honorable High Court's common impunged judgment, which is based on an analysis of relevant facts, the present appellants were cleared of all charges except for the offense under 411. But the convictions of all other offenses and the corresponding sentences imposed by the trial court were upheld. The defendants were offended by the impeached judgment and came before this court to contest the conviction as well as the punishment. The court subsequently gave notice on the specific sentence relating to the conjoined matter. And for the appellants, Mrs. Meenakshi Arora, a very prominent counsel, emphasis emphasized the particular court's ruling in Union of India versus Sriharan, which categorically held that the trial court lacked the niche authority to impose a specific term punishment or until the end of ordinary life as an alternative to the death penalty. However, it is argued that the High Court had disregarded this factor, which is sufficient justification for the overturning of the incorrect judgment. It was argued that the High Court had, in its contested decision, improperly dismissed the reasons presented regarding punishment while also dismissing the appeal on conviction. The argument had adjudication and examination of the order on sentence, and it was required even when the order of a conviction had been upheld or modified under Section 386B, subsection clause 1. And was based on the CRPC, which is the section 386. The appellate court had to specifically hear the accused on the quantum and the nature of the sentence imposed. When doing so, it is essential to request the officer's report pursuant to the Probation of Offenders Act or the results of a psychological assessment in order to decide the case. Now, Mrs. Meenakshi Arora argued that in order to exercise sentencing discretion, consideration should be given to mitigating circumstances. Relevant elements include the offender's age at the time of the offense, his or her chances of reforming while incarcerated, etc. In the court's ruling in Amit versus State of Maharashtra and Lakshman Naskar versus West Bengal, the probation officer's report, the jail conduct report, and the psychological report, all of which were created in accordance with this court's order, were strong evidence supporting good and normal social behavior, reformation, and the potential for reintegration into the society. And moving back to our present instance, which involves a murder, as per Mr. Chirag M. Shroff, who is another counsel for the state, argued that the conviction based on concurrent findings and punishment imposed were proportionate. It is argued that the covert act of kidnapping and the thinking process that drove the sequence of events were carried out with a lot of planning and were charted in such a way that all the dots were connected, the I's were dotted, and the T's were ticked. The family was led to believe that their son was alive, which led to repeated demands for ransom. It is noted that the extreme terror of the murder of such a young victim, nearly 18 years old, despite the appellant's education and wealth, showed that they were fully aware of their actions, kidnapping, murdering, and then burning and discarding the body's remains in a pool. And they knew exactly what they were doing. These factors, according to the argument, made this truly a murder out of the blue, which is most definitely the highest type of crime in our country. The council acknowledged that this court had held in Sriharan that only the High Court and Supreme Court had the authority to impose a sentence that is greater than life in prison, but less than death penalty. However, it is noted that this court had also rejected the idea in that judgment that the court imposing punishment should also impose the punishment of death or prison life, as prescribed in CRPC. Therefore, the judgment was not completely invalidated just because the Sessions Court had used this power. Instead, it was argued that because the High Court upheld the sentence, the spirit of law established in Sriharan, which I mentioned earlier, had been implemented properly. In case of Gauri Shankar versus State of Punjab, and this particular case was used as support for the sentence, which this court had sustained despite being passed outside the bounds of its authority due to the horrific nature of the crime. Mr. Stroff also argued that the neutral report provided in response to this court's instruction was insufficient to establish mitigating circumstances because it does not necessarily address the appellant's mental state at the time the charges were committed. It may or may not promote the idea of reformation or rehabilitation. And that concludes my analysis. Thank you.